From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Does the Constitution protect hormone therapies for transgender adolescents? The federal government argues that the answer is yes, in a case being heard today by the Supreme Court, which could have wide-ranging implications for other areas of the law. Welcome, I'm Kyle Peterson with the Wall Street Journal. We're joined today by my colleagues, columnist Alicia Finley and editorial board member Monet Ukwe-Barua. After a few big recent terms, the Supreme Court had a couple of quiet months since coming back into session this October, hearing cases that are important to the parties, but not any real blockbusters. That changes today, however, in U.S. versus Skrmetti. This is a challenge by the federal government to a law in Tennessee prohibiting doctors from administering medical treatments to minors if the purpose of the treatment is to enable a gender transition or to address purported discomfort or distress from a discordance between the minor's sex and asserted identity. The government is arguing that this is a violation of the 14th Amendment's guarantee of equal protection of the laws. Let's listen to a bit of Justice Elena Kagan. This is her tangling with the Solicitor General for the state of Tennessee.
One of the articulated purposes of this law is essentially to encourage gender conformity and to discourage anything other than gender conformity. And I'm wondering how you think that plays into the analysis.
I disagree with that characterization of our law.
Encourage minors to appreciate their sex and ban treatments that might encourage minors to become disdainful of their sex. Sounds to me like we want boys to be boys and we want girls to be girls. And that's an important purpose behind the law. And I understand that sentiment, but it's a fundamentally different sentiment, and it's a fundamentally different understanding of what produced this law than the one that you're talking about now.
Alicia, what do you make of this case and the arguments, particularly on the 14th Amendment, that the government is making?
I think the Solicitor General for the U.S. government is relying heavily on the Basta case from 2020. And if you recall that case, actually there were two cases, one involving sexual orientation and one involving gender identity, and whether those were protected classes under the civil rights laws, Title VII, meaning that employers cannot discriminate based on someone's sexual orientation or gender identity, and whether those were the same things as sex. And in that case, Justice Gorsuch joined the liberals, and and held that they were. It essentially created a prohibition against discrimination in the employment context. This is a very different claim. This is not involving the Civil Rights Act of 1964, and it's not really involving discrimination per se. The government is making the argument under the Equal Protection Clause of the Constitution, the 14th Amendment, and as applied to the states, that basically Tennessee and the 20 or so other states that have similar laws, they are discriminating against boys who want to be girls by not allowing them to transition. Now, there's a whole separate case of whether treating minors differently than adults. And again, there's nothing in this law that prohibits adults from undertaking treatments or pharmaceutical or surgeries for getting sex changes. But this is strictly applied to minors and seems to be creating a whole new class of rights under the Equal Protection Clause. And I think the justices overwhelmingly were somewhat disdainful of that approach in the Dobbs decision 2022 in terms of abortion, whether there was a substantive right to abortion. And here this is trying to create a substantive right almost for minors to get sex changes. This does not involve directly surgeries. It's actually more the pharmaceutical treatments, puberty blockers and such. But this would essentially create a right in 50 states for that.
To zero in on this constitutional argument being made by the U.S. and the Solicitor General on behalf of the federal government. So the 14th Amendment guarantees the equal protection of the laws. So this is a piece of the federal government's brief. It says a teenager whose sex assigned at birth is male can be prescribed testosterone to conform with a male gender identity, but a teenager assigned female at birth cannot. And so that is the argument, that whether the treatment is permitted under this Tennessee law depends on the sex of the patient. And so that is sex discrimination. But Monet, Tennessee's reply is that these two teenagers are not similarly situated. The law depends on the diagnosis. So there is explicit in Tennessee law that if there's a genetic defect that is being corrected, if there's disease, if there's a physical injury causing a hormone imbalance, let's say, if the patient is going through precocious puberty is the term, then those kinds of hormone treatments are perfectly allowed. And so the point Tennessee is making is that a biological male can get male hormones for some discrete medical problem that has been diagnosed, and a biological female who wants to transition cannot get male hormones, but could get female hormones. And so the argument that Tennessee is making here is that there are biological realities and treating boys, and that they're treating boys and girls the same by allowing them access to same gender sex hormones, but not cross-gender sex hormones.
Exactly. And this case, of course, made its way up through the Sixth Circuit Court of Appeals, which governs Tennessee. And the decision from two of the judges on the Sixth Circuit made exactly the argument, or affirmed the argument, that you are describing. The Equal Protection Clause of the Constitution says that like must be treated as like in like situations. So in something like employment law, which Alicia just commented on with Bostock, that of course means that a man versus a woman can't be treated differently by the hiring manager just because a woman is a woman. She can't be barred from taking the job, presuming that it's not a job where the sex is relevant to executing the duties. That's exactly the kind of protection that the Equal Protection Clause is meant to ensure. But when people have relevant differences vis-a-vis the law, then it is perfectly acceptable for there to be differences in how it's applied. In that sense, of course, a young man who is seeking to get testosterone treatment, that treatment is going to have a beneficial and restorative effect on his body because he's suited to accept it, and it's going to improve his performance, it's going to improve his systems, etc. Whereas someone who's biologically female receiving the same testosterone supplement is going to experience defects because of that. And this is all part of the relevant scientific evidence that Tennessee presented in making their case. So the courts have upheld the fact that there can be reasons why the law can treat different people differently if the situation that the law is being implemented with respect to is going to actually have different effects in practice. So you can't just neatly extend the Bostock precedent to the Skrmetti case because they deal with completely different substantive sets of effects.
Hang tight. We'll be right back in a moment. Welcome back. This is also an area of medicine where the guidelines have shifted recently and may be shifting more. It is notable that some European countries seem to have pulled back on some of these early transgender treatments, hormone blockers, and so forth. Earlier this year, there was a report in the UK called the Cass Review that suggested that gender medicine is, quote, an area of remarkably weak evidence, unquote. And then the Attorney General of Alabama, Steve Marshall, had an op-ed in the Journal's pages making the argument that the briefs in this case, this Skrmetti case, are relying on guidelines from a different group called WPATH, the World Professional Association for Transgender Health. And he's making the argument that those guidelines were drawn up in part in order to make them better fodder for these kinds of lawsuits. And so, Alicia, a part of the state's argument here is that this is a unsettled area of science and of medical treatment. There are disputes about how effective these treatments are, the rate of detransitioning, and so forth. And so that's a place where there is a classic right of a state to control the medical practice that is happening within its borders.
Right. And actually, you mentioned the Cass report from the UK, and that actually was very critical of the guidelines that were developed by the World Professional Association of Transgender Healthcare. And we've seen this movie before. You know, these experts put out these guidelines that are supposedly based on science, but they really aren't. They're social science. We saw this throughout the pandemic, right? And interestingly enough, many of the same quote unquote experts have written amicus briefs supporting the plaintiffs, in this case, the American Academy of Pediatrics, the Association of American Medical Colleges, the American Colleges of Obstetricians and Gynecologists, et cetera, et cetera. And there are actually a dozen medical associations that have written in support for the plaintiffs. But these are all very liberal groups. They have their own agendas here. And for the most part, they really aren't based on science. The whole transgender phenomena really hasn't been well studied, and it's really fairly novel. Yes, there have always been people who have identified as the opposite sex, throughout history, but it's really increased in prevalence. And one reason for that, or suspect, is because of social media and social contagions, and now some schools encouraging it. So it's almost become a way for people or young kids to actually deal with their mental health issues. And I think that gets to part of the problem, is that these treatments, these pharmaceutical treatments, are really intended to address a symptom of a problem without actually addressing the problem. And what I mean by that is these kids who are identifying as different genders or other than their biological sex, a lot of them suffer from depression and other mental illnesses, and just giving them puberty blockers, testosterone, estrogen, or whatever, that doesn't solve the underlying issue. They still go on to commit suicides at higher rates. So this is almost, in some ways, a Band-Aid. And Monet alluded to as well, is it can make the problem worse. It can make physical health problems worse. There's some evidence that some of these treatments can actually increase cancer rates and result in the higher later in life. And so there's just a lot that hasn't been studied about this. And I think they're trying to use science and medicine to try to justify something that they can't even justify based on the law.
I'll say a few words about the 2020 Bostock decision, which I agree has invited these kinds of challenges. So to reiterate, that was a 6-3 decision by the Supreme Court in 2020. And what it essentially said was that the Civil Rights Act's ban on employment discrimination by sex, that phrase by sex includes sexual orientation and gender identity. And here's a piece of the majority opinion by Neil Gorsuch. He says, imagine an employer who has a policy of firing any employee known to be homosexual. The employer hosts an office holiday party and invites employees to bring their spouses. A model employee arrives and introduces a manager to Susan, the employee's wife. Will that employee be fired? If the policy works as the employer intends, the answer depends entirely on whether the model employee is a man or a woman. So his argument there, this was the argument by the 6-3 majority of the court in Bostock, was that discrimination by sexual orientation or gender identity necessarily is discrimination by sex in the context of the Civil Rights Act. And that example, that hypothetical, that logic sounds a little bit like what the federal government is saying here with respect to hormone treatment, that in order to know whether the adolescent in Tennessee is allowed to get testosterone, you must know the sex of the adolescent. It's impossible to interpret the law any other way. But Monet, that does raise the question of how broadly then this logic holds. And Tennessee's brief is arguing that if the Supreme Court were to take that logic of Bostock out of the civil rights context and constitutionalize it and put it into the 14th Amendment, that it would have very broad effects. Here's a part of the Tennessee brief. If the government's theory holds, men who identify as women could claim constitutionally based access to women's bathrooms, women's locker rooms, women's sports. Accepting that theory would perversely erode women's rights and jeopardize landmark statutes protecting women's equal access to schools, winners' podiums, and beyond. This was clearly on the minds of at least some of the justices. Let's listen to Justice Brett Kavanaugh asking the question of the Solicitor General of the United States, Elizabeth Prelogar.
Do you think it's logically possible, as a matter of constitutional decision-making, to say that laws like the ones that one at issue here do not satisfy intermediate scrutiny, but laws that restrict women's and girls' sports in a way that transgender athletes cannot participate would satisfy intermediate scrutiny. Is that logically possible?
Oh, yes, definitely. So we do think intermediate scrutiny applies in both contexts, but there are a different set of state interests at play. And I think one readily apparent difference is that in the context of sports, there are arguments made that affects the rights of cisgender women, and that the ability to allow transgender women to compete on those teams is going to be other regarding in the sense of having those external impacts. There's nothing like this here. Allowing transgender individuals who have carefully thought about this and consulted with their parents and their medical team to access these medications that have health benefits recognized here and abroad in no way affects the rights of other people.
Monet, I'll say one thing first. Elizabeth Prelogar, pretty good at her job. I wouldn't be surprised if she is on a short list someday for a Democratic president's Supreme Court nominee following the path of Elena Kagan. On the other hand, I don't know how comforting it should be to that question if the answer is that, yes, we think judges should look at these kinds of questions with intermediate scrutiny. And so if you rule in favor of the government's position here in this Tennessee case, then the answer is in the future, there will be a challenge about women's sports or women's bathrooms or whatnot. And the judges will have the authority under intermediate scrutiny to weigh the claims. What are the state's interests and what were the projected harms if they allow men who identify as women into those spaces or vice versa?
Well, I definitely think that you're overestimating Elizabeth Prelogar, at least with regard to that clip, because I think the argument that she makes doesn't hold up to even very slight scrutiny, in that she's saying that because in the case of a sports team, for example, somebody claiming a gender identity other than their sex would affect the other players on that team, then it warrants more heightened scrutiny than the question of whether they can receive hormone treatments. But the history of civil rights law and how it's always been interpreted has always dealt with questions where other people are affected by how the state treats the claimant. For example, if a Black person wanted to be admitted to the armed services before the U.S. integrated, that doesn't only have to do with their own right to serve. It has to do with whether the company feels that that person can be welcomed into that context and they can perform in an integrated unit. And the government has consistently decided that the rights of the individual to be equally protected under the law take precedence over the rights of that unit to say that we have questions about whether this person fits on this team. And so it is absolutely true that if the Supreme Court were to rule in favor of the government in this case and say that people with a different sexual identity have the right to receive these types of treatments, they would be essentially blessing the notion of sexual identity that doesn't match with the birth sex of the person. And then that would very easily be translated to all these other contexts. And it would be almost impossible for the courts to say that the rights of the group that they're trying to integrate into, in the case of a sports team, in the case of a prison or something like that, can actually be considered as a compelling interest to restrict that individual's rights. So I think that the justices are exactly right to be skeptical of the idea that this decision could be limited in its scope. They understand that if they rule in the government's favor, essentially they would be creating broad rights for sexual identity, preventing states from passing any laws that limit it or treat people with a different sexual identity different in any context. And so they know that that is something that is very, very serious for them to take out of the hands of state legislatures and put into the realm of the courts when there is no historical precedent suggesting that sexual identity is the sort of protected class that has always been protected under the Equal Protection Clause.